Ms. Zenani, let me start by apologizing to you. You know, I know, yeah. Generally, under normal circumstances, we give you time to consider and do your research and to give us a well-considered view. We apologize that we had to call you hush-hush to come here. It was something that was not planned for, but we thought that it would be important that we get legal advice that to guide the process. So please accept our humble apologies for doing this to you. It was not intentional. So I think you might have been briefed that the issue that we require some guidance on, we have a member of the panel here who was represented by a person who is going to be interviewed. In fact, that person is representing her pro bono. And there is also another person to be interviewed who has worked with that particular member, and there were disciplinary processes that were done. So there was an issue of conflict of interest, whether that member should recuse, whether the member of the panel should recuse themselves or should just declare. So we thought that if we can get a guidance that's legally, are we on a good side to proceed? Yeah.
Thank you, Chairperson, and apology accepted. We received the brief instructions relating to a recusal or relating to whether or not a member should recuse themselves based on a perceived conflict of interest. The instructions that we received were that the candidate is a practicing advocate, and we are made aware now that there is another candidate as well that will be interviewed, wherein the same member conducted a disciplinary hearing against. The issue of conflict of interest in terms of the National Assembly processes, Chair.
Sorry, before you proceed, it will be a conflict of interest and perceived bias.
Perceived bias. Okay, thanks, Chair. So, as you may be aware, the issue of conflict of interest is governed within the space of Parliament by the rules. The National Assembly rules, Rule 30 in particular, will say if a member has a personal or private financial or business interest in any matter before a forum of the Assembly of which he or she is a member, she or he must, at the commencement of the engagement on the matter by the forum, immediately declare that interest in accordance with the Code of Conduct contained in the schedule to the joint rules and comply with the other provisions of the Code. The Code, Clause 5, says that a member must always declare such interest, and where appropriate, the member should recuse himself or herself from any forum considering or deciding on the matter. The Code also says that the member must declare any direct or personal or private or financial interest or business interest that the member or any immediate family or that member or any business partner of that member or immediate family of that member may have in a matter to be considered or decided on before any parliamentary committee or other parliamentary forum of which that member is a member or in which that member is participating. So I understand that this hurdle has already been passed because I want to believe that there's already a declaration that is...
Not yet. The two people have not yet been interviewed.
All right, but the rules say that the member must declare, so it is the responsibility of the member to declare. Furthermore, with regard to the candidate who is a practicing advocate, the Legal Practice Council Act, Section 29, says that the minister must, after consultation with the council, prescribe requirements for community service from a date to be determined by the minister, and such requirements may include a minimum period of recurring community service by practicing legal practitioners upon which continued enrollment as a legal practitioner is dependent. So there is a duty on the practicing legal practitioners to perform community service during the course of their work. So there is the first requirement is that there must be a declaration by the member. Second, if there has been any pro bono that has been performed by a candidate who is a practicing legal practitioner, there would not have been anything untoward about it because it is prescribed by the Legal Practice Council. Furthermore, there is quite a few court decisions that have dealt with the issue of recusal based on possible conflict of interest. One case that comes to mind is the President of the Republic of South Africa versus Sarfu. Just need to check. Well, I can, if required, bring the full citation, but basically the principle that we elicit from the case is that the question that must be asked in circumstances where there is a perceived conflict of interest or perceived biasness is whether a reasonable, objective and informed person would, on the correct facts, reasonably apprehend that the judge has not and will not bring an impartial mind to bear on the adjudication of the case. And it goes on to further say the reasonableness of the apprehension must be assessed in the light of the oath of office taken by the judges to administer justice without fear or favor and the ability to carry out that oath. So a conflict of interest must be assessed as against what the case law says. It is not sufficient to just say we have worked together in a matter, as is the case in this particular case, but there must be that assessment as set out in the court decision that I've read out. Furthermore, the members of parliament also take an oath of office, and I would like to believe that on the facts presented, we cannot preempt that there is any conflict of interest unless there are any other facts that we are not privy to. Thanks, Chair.
Thank you. That is, you are done, Mr.
That is our preliminary review, Chairperson, considering the timeline that we've been given
which is understandable,
to present the opinion.
Thank you very much. That is the opinion, members. Honorable Breitenberg, Honorable Horn.
Thanks, Chair. Clearly, we disagree fundamentally with this legal opinion. I believe the legal opinion is flawed in its entirety. I ascribe that to the short notice that was given to prepare. In circumstances where somebody is currently appearing pro bono for a member of this panel, and there's a financial benefit for the member of the panel in that relationship, to interview that person for a job, there's not only a clear conflict, never mind a perceived conflict, there's a conflict of interest and definitely a perception of bias, and it's ineluctable, and it's inconceivable how that cannot be seen in this legal opinion. Again, a member of this panel is going to interview a candidate who worked for her, who was disciplined by her, who was terminated by her, and then went to the Labour Court and that termination was overturned and she's still in the Office of the Public Protector. I disagree fundamentally with respect with this legal opinion, and I'll need a little bit of time to consider our position.
Honorable Horn.
Yeah, Chair, I also wanted to say, while I perfectly accept that we actually are putting parliamentary legal services in an unfair position, of course, legal advice also largely, or the credibility of it, depends on the completeness of the brief. And I would want to hear from the representative whether her advice and opinion on the pro bono services would differ. After I've pointed out to her that the Legal Practice Council, as a matter of fact, has embarked on a process of regulating pro bono services, but it is within the context, of course, of indigent clients, where there is then an obligation on legal practitioners to render pro bono services. It's much, not to make it too complex, in the old days there was a practice which we called informa pauperis, where the registrar of the court could, once indigent prospective litigants would arrive at the registrar's court, issue an informa pauperis directive to practitioners on a rotational basis, and that placed them under an obligation to assist free of charge. Now it's being brought under the helm of what we know as pro bono services, but I would want to strongly argue that that vastly differs from a situation where somebody is litigating in front of an international body, as is the case here, and where the candidate has then seemingly, on the information available to us, stepped forward and said, but I'm making my services available to you at this international African forum on a pro bono basis. That would mean, firstly, and I want you to consider that there's clearly a financial benefit to the litigant, because in ordinary services, the ordinary course of events, that litigant would have had to pay for it. But secondly, there's also the complexity that there is more than the ordinary pro bono enforced relationship in respect of the candidate who's appearing today, the advocate. If that candidate stepped forward and said, because I believe in your case, I'm going to assist you in a pro bono matter at that forum, that clearly talks to a much closer relationship than would ordinarily be the case for a practitioner, wouldn't you agree? Thank you.
Thank you, Honorable Mola.
Thank you very much, Chair. Chair, I think let's first agree that this is just but one step towards many steps towards the appointment of the Deputy Public Protector. Given how now we're arguing in this committee room, it does seem like Honorable Mkhwebane should have recused herself the day we received the master list and we saw the name of Tebele and Mokhalat. Was this a process that she has been involved in throughout? Just part of the engagement, Chair, is that in the last meeting where we sat and agreed about the shortlisting, Advocate Mkhwebane was fully participating in that meeting. So it is quite unfortunate that we are now only discussing the possibility of bias, the possibility or the perspective, the perception of bias, sorry. But I equally find it unfair and legally incorrect to say there is a relationship between Honorable Mkhwebane and these two candidates, but we say she must completely recuse herself when 8 candidates are about to be interviewed. To me, that argument does not hold water. They say in the worst case scenario, there was indeed a proven perception of bias on her side. In my view, it would have warranted her to recuse herself in the interview of these two specific candidates, not everyone in the list. Lastly, Chair, it does appear from both what Honorable Horn and Honorable Breitenbach are submitting that the relationship between Honorable Mkhwebane and Advocate Tebele and Mokhalati is strictly a formal professional relationship. That in the submission, it does not say that beyond this which is submitted, there is a personal relationship between the candidates and the honorable member. So from where I'm seated, Chair, that this relationship remains a professional relationship. The other one from another office, the other one currently. So I would actually submit as well to the committee that let's proceed with the NA Rule 30 that says a member must declare a particular relationship they have with that particular candidate. So, Chair, I just wanted to move that way. And we must, Chair, actually thank Advocate Breitenbach and Honorable Horn for raising this matter with us, so that we are able as the committee to make deliberations on it, apply our minds, call the legal unit of Parliament to come and assist the committee, so that we don't proceed regardless of what is happening and get to have problems in the near future about what we are engaged in. I think it is important that the committee must thank them, but I think I move with the submission that we must proceed in line with Rule 30 of the National Assembly rules, that the member involved must make a declaration. Thank you very much, Chairperson.
Thank you very much, Honorable Mkhwebane, Honorable Engelbrecht, Honorable Janche.
Thanks,
Sorry, before, I think Honorable Breitenbach had her hand. Are you still? Okay.
Thank you, Chairperson. Thank you, Advocate. Are you Advocate?
I am not advocate. I'm an attorney of the High Court of South Africa.
Okay. You know, this agency was unfortunately created by the very same DA, because indeed, in the first place, apology to you to be just placed in this position unnecessarily, because DA should have raised this query, as Honorable Ngola is saying, when we were conducting the shortlists, and say this is a challenge we are having. And now, even EDA, they just rush to Honorable Breitenbach or Honorable Horn. You know, I was still going to declare, because I know I'm supposed to declare. And what is worse is that now they raise this here, taking our time to interview candidates. Candidates have been flown in. The state is wasting resources to fly people in. Some of them might have booked earlier flight. Now we are going to delay them. When we change flights, we are losing money. So I think that's also one of the things which they should be accountable for. But then another thing, I'm not the sole decision maker in this matter. The matter is a committee decision. When we identify a candidate, that candidate will be the decision of the committee, not me alone. And again, she's misleading the committee who advocate Breitenbach. The Bonam Mokhaladi was never dismissed. The letter was saying, show cause why you shouldn't be dismissed. That is there throughout the papers, not to say there was a letter which says you are dismissed. So that's very wrong of her to even mislead this particular committee. Who advocate Tibeila is a public defender, a person who do any matter anyway, who saw the cause of the public protector and said, I am also doing the work with the African Union. I can do this matter. I've done several matters which he can present himself if he does that. And indeed, I have no knowledge and relations with Advocate Tibela. But the fact of the matter is that they just, tjatjarag, but she rushes to raise this matter instead of waiting for me and hear from me whether I'm going to declare. And I was still waiting for her as well to declare, because there is recorded evidence which shows that herself has been communicating with Ms. Mokhaladi throughout my term as the public protector. So I think it was going to be very interesting as well for her to say, I know this person, I always communicated with her, I'm the one who also gave this information, I raised these parliamentary questions because I was engaging with her. So I think Rule 30 is very clear, and I'm not the sole decision maker, and I'm here just for the people of South Africa to make sure that we identify a correct person. Thank you, Chairperson.
Thank you. Before we proceed, I think Ms. Zenani, also if you can comment on that one, because I think it's an important principle where a member is part of the committee, not the sole decision maker, if you can touch on that. No, but when you respond, I think they're still raising issues. It was Honorable Engelberg.
Thank you, Mr. Chair. I just would like to know from the legal advisor if her name is Singizwa.
Yes, that's correct.
Thank you, Chair. My name is not Zingiswa, it's Zingisa.
Zingisa. Okay, and did you work for the public protector while Ms. Mqwebwane was the public protector?
No, I did not.
You did not. Okay, I just wanted to clear that. Thanks.
Sorry. Let's focus on the legal opinion and guidance that is being sought for us to conduct these interviews. Please. Honorable Janji.
No, Chair, let me admit that I created an oversight on my part. I had intended, before you asked her to speak, that we needed her to have a little bit of a listening to us first. You know, there's something called quick and dirty in research. So we have asked her to come and give us a quick and dirty legal opinion. And she had a hit and run kind of an advice. Nothing was presented to her. That on its own, Jay. And I think that's unfair. It's like window in the corridor, legal advice. Because she has come into the meeting, she needed to, that's the oversight I'm saying I've created. She needed to sit and listen. Because even now, I don't expect that she would have a comprehensive response or a standing legal advice. From where I'm sitting, she's here to listen. Chair, I just want to say that. And for that, I would want to suggest that we give her time, Chair, also to consider all of these issues having listened, because we are going to need that well-considered legal advice in terms of this process, even when we concluded this matter. I agree that on consistency we should proceed, but subject to us receiving this legal advice. It's going to be important, it's going to help us, and so that she is able to apply her mind fully on all of these issues. Now she's just getting sabotaged by all of us here. Since make a brief immediately it says and I'm saying that's not and therefore my concrete suggestion is that because some of these things that are here are not new. We've just interviewed the South African Human Rights Commission I sat here and declared on 3 candidates. I would have been part of the shortlisting of those 3 candidates: Chris Nissan, Andre Gam, and Gongo Bele. And I know them very close, for that matter, and I declared as such that's where I would have worked with them and so on. And Honorable Kola makes an important point that whatever legal advice we give must be a fully fledged one that starts from the process when it started, and not just picking up a particular issue. Because here, there's a specific issues that are being raised in a very preemptive manner, because it's something else when these candidates would have been here and there would have been no declaration. And then you raise some serious questions. So I don't know if I'm helpful, Chair, but I would want to, even though she's going to respond, and I will take her response as a just off the cuff at this stage. We need to give people that who must give us proper legal advice space and time for them to advise us properly. So thank you, Chair.
Thank you. I think the legal division of Parliament, they know exactly how we operate under normal circumstances. We take their expertise and their legal advice very seriously, and we always communicate with them in time. But it was a serious issue that came in the morning, and we needed to get some form of a guidance so that we don't act arbitrarily. We know that there was not enough time to give us a considered view, but we do have a sense now as to whether we agree or we disagree with the view, but we do have a sense. I think we can be able to make a decision. But Mr. Nane?
Before you go, Chair, I think there's one important other aspect that just must be put on the record. A formal finding by this Parliament about the Mogolade issue. Ms. Breitenbach will read it into the record.
Okay. Thanks, Chair. So this is an extract from the Section 194 report.
Oh, from?
The Section 194 report. Yeah. Advocate Mkhwebani's rejection of the outcomes of the disciplinary process, the tenor of her letter imposing summary dismissal instead, and the lengths to which Ms. Mogolade and Mr. Kelly were compelled to go to vindicate their rights and secure their livelihoods, caused members to conclude that Advocate Mkhwebani's conduct constitutes either victimization, alternatively harassment, alternatively intimidation against both Ms. Mogolade and Mr. Leke. That is an extract from the Section 194 report. I can make that available to the legal advisor if she so desires. And I understand that in my absence, Ms. Mkhwebani said that I should declare about Ms. Mogolade. I don't know if she's here. I don't believe that I've ever met Ms. Mogolade in my life. But when she arrives, if I do know her, rest assured, I will declare.
Thank you very much. Ms. Zenani, I think let's agree that we would not continue to, some of the issues you would need to be, they would need to be part of a well-considered opinion. I think there's information that you have just heard it when you are here. We did give you a glimpse. The committee secretariat spoke to you about what we needed, and you had to do a quick reading. I think it will be important at least to stick to those things, because we do not want a situation where we will just continue to put you in a very difficult position. If you can just respond to some of those things, but you can give us a well-considered opinion later.
Thank you, Chair. I just want to acknowledge also that some of the information is slowly coming out now. Some of the facts were not necessarily privy to. For instance, the issue of Advocate Tebela currently representing Advocate Mkhwebane. We were not alerted to that. My understanding was that it's he had previously represented, so they know each other from that case. I was not aware that the matter is ongoing, the representation is ongoing. So I would like to look into that, to be given an opportunity to look into that. I do not know if it will change my stance, but I would like to revisit that. Secondly, the issue of the disciplinary action by Advocate Mkhwebane against Ms. Mokhaladi. My preliminary view on it is that it's something that happens within the scope and course of work, nothing outside the labor laws of this country, unless the judgment, the labor court judgment, point out to the issues that, that for instance, Advocate Bredenbach is talking about, issues of victimization, then maybe based on that, maybe our position would change on that. I do not know. I would have to look into the judgment. I would have to look into the details about Ms. Mokhaladi in the Section 194 report, which you did not get an opportunity to revisit. The issue of pro bono representation, I would like to believe that there is a means test that the LPC applies. Where I am sitting, I am unable to say that Advocate Mkhwebane would not qualify for pro bono. That would need to get facts on it as well. There was an issue about Advocate Mkhwebane being part of the committee, but not necessarily the sole decision maker. I believe that the decision that will be taken here, the recommendation that will be taken here will be taken by a collective within the multi-party democratic government that the Constitution talks about. So I do not necessarily think that there is a particular individual that is the sole decision maker. I believe that it will be a collective decision that will be presented to the National Assembly. And as Advocate Bredenbach has pointed out, I would like to revisit the Section 194 report to look into the issues of victimization attributed to Advocate Mkhwebane as against Ms. Bonatsago Mokhaladi. And as you have alluded to Chairperson, I would like to be given sufficient time to prepare a proper opinion on the facts that have been presented in this room today.
Just for my interest, how material it is and how fundamental it is that if she is not the sole decision maker and the committee proceeds, that can fatally taint the whole process if she's the only person. Let's say she is materially conflicted as an individual. You have a committee of about 9 people. How fundamental it is
that she is not the sole decision maker. If there is evidence that has been presented that she is conflicted, then
yes,
I would propose that she considers recusal. Otherwise, like I said, I do not. I would like to believe that she's here to make contributions and inputs to the process, and inputs that will be taken into consideration for this committee to arrive at its decision.
Now, if she refuses to recuse herself and the process continues, how fatal can that be?
Well, Chair, if there is evidence that there are some candidates that were prejudiced as a result of her being conflicted, or that some candidates benefited as a result of the conflict of interest, then in my view, it will affect the entire process.
Okay.
Yes.
Members, can I suggest maybe that we have a 20 minutes break, and please be around.
I will be around, Chair. Thanks.
Thank you.
Chair, sorry, just for ease of reference for the legal advisor, the piece that I'm referring to in the report is page 29 of 64 pages.
What? Can you repeat that? I was sorry.
The piece that I read out is on page 29 of the Section 194 report. Just so that she doesn't have to trawl through the whole report to find it. 29.
So can we have the 20 minutes break?
Short section.